Hello, Dr. Mensch, classmates. I'm looking forward to attending the next sync session with you. Unfortunately, other events kept me from participating in the one that we just had, but I'll be presenting on illegal wiretapping in the United States. I'm going to go through three specific elements for this presentation, including some of the legal documents that are in existence concerning wiretapping. And I'm going to go through some examples of some wiretapping incidents that were illegal. And then I'm going to provide some opinions about that, specifically kind of what I think the outcome is of illegal wiretapping and some of those regulations. To do this, I want to start out with some recent legal history and establish really what's going on with this. My background is as a United States Army counterintelligence agent, and there's a couple of documents that dictate or that govern some of the special intelligence collection techniques that we used. So Army Regulation 381-10, and this is the unclassified version on your screen here of the Army Human Intelligence and Related Counterintelligence Operations Manual. But inside of these documents, there's 15 special investigative procedures, and among them is Procedure 5, electronic surveillance. And so that's the equivalent of wiretapping. But the scrutiny that's applied to these in these two documents is that the special or the approval for these special procedures has to go all the way up to the Secretary of the Army and the Department of Defense General Counsel to the Attorney General. So it's a big deal to even get this approved. It has to go up to the highest levels. And just by contrast, to get something for physical surveillance approved, it only needs to be delegated, or it can be delegated all the way down to a battalion commander for military intelligence command. So electronic surveillance has a very specific and high threshold for approval for instances of application in the military. Now, this presentation isn't an introduction to U.S. Army regulations, but the idea here is to highlight the extreme measures that the United States government Department of Defense employs to ensure these activities only fall within legal parameters. So unfortunately, despite the efforts made to govern these extreme investigative techniques, as this presentation is designed to illustrate, the temptation to abuse them is occasionally too great to resist. So I want to look at three specific things. I'm going to discuss two or three more legal precedents, but I want to talk to you about three examples of some cases where these things apply. I'd like to highlight too, though, wiretapping doesn't necessarily have to include a wire. The term refers to the practice of utilizing a covert listening device to capture an information transfer. So that could be a conversation, it can be a listening device, or even analyzing the contents of whatever that is that's transferred. So it doesn't even have to be an audio event. But because this is typically conducted by electronic means, the tactic has come to be referred to as wiretapping. So we've got U.S. Code 2511, the Electronic Communications Privacy Act of 1986. That's come to be known as the Wiretap Act. And that defines the legality of covert listening acts by specifically designating where it is illegal to conduct them. So the standard under this act is that it is illegal to intentionally or purposefully intercept, disclose, or use the contents of any wire, oral, or electronic communication through the use of a device. That's a very specific definition of what is not permitted. That act was an example of an expansion of the 1968 wiretap statute, which was titled and Safe Streets Act of 1968. And then in recent years, we've seen several other additional parameters applied to wiretapping and its constraints, including such things as the Communications Assistance for Law Enforcement Act. Many of you are familiar with the Patriot Act, and there's other FISA amendments that apply to this. So let's move on into some of the specific examples. I want to start off with a case, I've called it the FBI in the San Mateo County Courthouse. The FBI was in the middle of a legal battle, and most of us would consider that to be recent news, but this is actually a case that occurred about a decade ago. And this wiretapping case regarded the use of a covertly placed recording device on the steps of the San Mateo courthouse. The question here was whether or not the people that were being targeted by these wiretapping events had a reasonable expectation of privacy in a public place. The outcome of this challenge actually went in the favor of the people who were conducting illicit illegal activity. They had been participating in bid rigging at a public foreclosure auction that was conducted on these courthouse steps. And the court determined that the plaintiffs, because they were suing that their privacy rights had been ignored and abused, that they had a reasonable expectation of privacy when speaking discreetly off to the side from the auction away from others. So this reflected the same opinion that the 1967 Supreme Court ruling was, where a defendant's actions determined whether a public conversation was intended to be private. So these guys stepping off to the side, discussing things discreetly, dictated that that was a private conversation. The 1967 Supreme Court ruling had to do with somebody going into a phone booth to talk, and the fact that they would close the door meant that they intended it to be a private conversation. So in this case, the end state was that all of the evidence that they had gathered, including over 200 recorded hours, was thrown out, and the information that was collected pursuant to the information that they were able to garner from those conversations was also thrown out, and there was no criminal prosecution for the illegal activities that they knew full well had occurred. So moving on now into another example, and this one also involves the FBI. And this one, as you see here, came out in the newspaper because there was a ruling that this conversation had to be made public. And this happened in a Supreme Court ruling also in 1967 after the phone booth privacy ruling. And this had direct bearing on the admissibility of evidence gained by the FBI through illegal wiretapping conversations. In this case, between the mayor of Elizabeth, New Jersey, and the reputed mafia kingpin Sam the Plumber Decavante. There's Sam there. Some of you guys may have seen some of the events that had to do with this acted out in some HBO special events. But so this was a case where there were 3 defendants. They were accused of participating in an illegal dice game. Not just participating, actually, they were cheating and stealing from the other people there. They were extorting them and in effect creating a further illegal environment. But the FBI had bugs planted at the Barn between 1961 and 1965. This was a nightclub owned by another mafia captain, Angelo the Gyp DiCarlo. You might recognize him from either side of these photos as well. But ultimately, the Supreme Court here also ruled that the conversations obtained by these wires were placed illegally, and that the information obtained from them was inadmissible. So not only inadmissible, but in a really strange twist, the transcripts were then ruled to be made available to these defendants so that they could determine whether or not the recordings had been obtained legally. So I'm sure that it's not a surprise that as they were listening to their own voices on these tapes, they were able to determine that, no, those were not obtained legally, and so therefore they were not admissible. So I want to move on into our third case that we'll talk about, and that's again with the FBI, and kind of establish here that past precedence is kind of the foundation of modern law. So the past, and this is an example from the past, it continues to be relevant as we look at the merits of our laws today. This is going to be important as I wrap this up in my conclusion. But in this final example, we see where the FBI knowingly engaged in illegal wiretapping, not knowingly engaged in wiretapping that turned out to be illegal, but they knowingly placed wiretaps that they knew were illegal when they placed them. They made no effort to bring about prosecution, however, in these criminal cases because they knew their information was illegally obtained. But they still valued that information. It was important to them. And this is another case of a mafia crime, and it's covered in David Rennie's article on this subject called "Hoover Lets FBI's Mafia Snitches Get Away with Murder." And his recounting of this appears to be, the title of this appears to be entirely accurate. But the recordings began in 1965 And there was evidence where several people specific to this case were known to have been involved in over 20 murders. Well, the first one you see here, Joseph the Animal Barboza. Next one, we got Stephen the Rifleman Fleming, and that's him here on the left. The reason he's pictured here with James Whitey Bulger, and this is one of his earlier mug shots, is that Fleming ultimately ended up testifying against Bulger, but Bulger was a guy who was also testifying and reporting to the FBI. He was the snitch. Back in the title again of David Rennie's article, Hoover lets FBI mafia snitches get away with murder. Well, these three guys were involved in a lot of murders. And the reason that the FBI knew about these murders was because the FBI had bugged the New England Mafia headquarters. So despite their direct knowledge of one of the informants killing a fellow named Edward Deegan in 1965, they stood by and let false testimony stand in a trial about the murder that they knew was conducted by one of their informants, and they allowed an innocent man to be sentenced to death for that murder. And that was the FBI's role in something that they couldn't intervene in because the knowledge that they had was obtained illegally. Now, in another interesting twist, now you see here in this photo, Whitey Bulger's older here than he is in his mugshot. But last year, Whitey Bulger was who ultimately ended up in prison as a result of Fleming's testimony against him. He was transferred to another high security prison facility, but this was a particularly violent facility. And in the end, Whitey Bulger basically suffered the snitches get stitches outcome, and he was murdered in prison, and it was a padlock and a sock, and that's kind of a typical mafia hit in prison for someone considered to be a snitch. That's how that one played out. So you might think from my evaluation here and the instances that I chose here that I think the FBI is corrupt, and that's kind of the theme that today's media would have you to believe. But that is not at all the point that I want to make here. It would, in fact, represent a conflict of interest for what I do for a living. But each of these FBI cases, they're using all of the resources that they had at their disposal to complete their mission. And their mission is to protect the American people and uphold the Constitution of the United States. That seems kind of like a paradox since they're defying laws in upholding the Constitution of the United States. But because of the circumstances and restrictions of their illegal activity to monitor other illegal activity, what we see is people that conducted this illegal activity going unpunished. And their efforts to protect the American people is what ended up having been punished, as they're highlighted as the criminals. And that's, again, I think where we get this bias in the media that says law enforcement agents are doing things illegally and the American people are suffering because of it. Now, I fully acknowledge that that is my opinion, and there's a bias there based on my past. But I mentioned in the introduction to this paper that I have biases here. I spent my career in the United States Army as a counterintelligence agent, and I know firsthand how difficult it is to catch a criminal red-handed. Not because they're not willing to commit crimes that you can catch them at, but because it's difficult to get the approvals to access the things that you need to do to get that information, such as these wiretaps. So consider the difference in approvals, like I said up front, that it takes to conduct physical surveillance instead of electronic surveillance. That was the difference between, in the military, Procedure 5 and Procedure 9. Physical surveillance, and that is you following someone around, watching and taking pictures of their activities, that can be approved by the commander of the Intelligence and Security Command. So that's 4 command levels below the Secretary of the Army, where you have to get approval for electronic surveillance, a presidentially appointed cabinet level official. And so the authority to approve physical surveillance, it can be delegated from that Intelligence Security Command down to the commander of a military intelligence battalion. So I agree with that delegation, but what I think is that that delegation could also be applied to electronic surveillance, to wiretapping. I think it's an appropriate standard, but I think that same standard should be applied to the other effective law enforcement mechanisms of electronic surveillance. and that instances of abuse of this procedure, as I think I highlighted in my presentation here, they should be individually adjudicated based on the merits of what it is that information surfaces. I realize that there's a lot of opportunity to abuse that, and I think that those need to be prosecuted criminally, but I think those abuses need to be weighed against what the intent was. So I looked at, and I hopefully established for you some foundation and legal precedents for wiretapping restriction. I hope you were able to enjoy a little bit the 3 examples that I provided there. And again, I acknowledge that that's my opinion there, but I purposely chose those examples because I think that they highlight specifically what I'd like to be acknowledged about illegal wiretapping and some of the circumstances that might lean in the opposite direction of where the public might think that our engagement needs to be. Thank you guys very much for listening, and I look forward to presenting in person for you guys, or at least live for our next sync session. Bye-bye.